Good afternoon, everyone. It's 4:30, so we should begin. Welcome to a conversation called Reflections on Interpretation and Serving in the Judiciary. So this is a panel discussion that I will moderate with Justice Stephen G. Breyer, retired of the United States Supreme Court. And
my brother just waits till I get somewhere, then he calls me. Happens all the time.
They call them brethren on the Supreme Court, too.
No, it's usually either my brother or somebody trying to sell me something. Where I can't find it. There it is.
And we also have here Justice Syed Mansour Ali Shah of the Supreme Court of Pakistan. I'm Professor Intisar Rab. I am a professor of law here and a professor of history also here over at the university, and director of the program in Islamic law here at Harvard Law School. This event is co-sponsored by the International Legal Studies program at the Harvard Law School, along with the program in Islamic law here, and the Lakshmi Mittal and Family South Asia Institute at Harvard. So thank you to everyone at all of these organizations who have helped organize this event and bring us together. So a couple of housekeeping items before we get started in earnest. This session is being recorded. We ask that you keep questions to questions about the law. Actually, Justice Breyer says you can ask him anything. He just won't answer if he doesn't feel like answering.
I could do the same, actually.
And we hope to have questions at the end, or time for questions at the end from all of you. So for that, we will have some index cards and folders that are over here on the table next to the door. And you can please write down your questions, and I will collect them around 10 or 15 minutes before our scheduled end time. So without further ado, I will only briefly introduce the justices, or actually ask that they introduce themselves by way of a story, because I think you know who they both are. And I will first turn to Justice Breyer, who, as you know, has served on the Supreme Court since 1994, has just stepped down this year from the bench. And I'd like to just ask you a general question about what led you to the bench. Can you remember first stepping onto that bench?
Which I was a judge in the First Circuit.
To the Supreme Court bench.
Oh, the Supreme Court bench. Well, the Supreme Court bench, Cliff Wallace, is who was a very good judge in the Ninth Circuit. It's like picking the gold ring in the merry-go-round. I mean, it's a lottery. Now, it's not a lottery everybody in the world. And the year before, I'd been considered and not selected. And Ruth was selected. And people asked her, Ruth was a very good judge. Hey, and I knew that at the time. And so I said that. And it's quite true. You can congratulate yourself, nobody else will, and pat yourself on the back about being somebody who's being considered. I mean, you probably have to have done a reasonably good job. But among the 10 or 15 people who, in honesty, you have to say, hey, I don't really know on any merits, what is it? There's a lottery. And so for it's luck. And every member of the court knows that. I promise you. And there we are. So Tolstoy, according to Lee Campbell, who's a colleague of mine on the First Circuit, has one of his generals saying, it doesn't matter how you're selected. What matters is what you do after you are selected. That's what counts. All right, end of story.
And we'll hopefully have chances to talk about what you did once you were selected during the course of this hour. And if that's the end of the story, I
No,
might...
all right, if you want something comical. I'm sitting in my office there in the First Circuit, and the news is all saying there are 5 people, and President Clinton's going to decide which one. And Bernard Shaw was the man who announced. He said, "I think he's chosen Judge Breyer from the First Circuit." Well, nobody told me. So I sit in my office, and Joanna's mother wasn't well in England, so she was over in England. So she phoned and said, "Have you heard anything?" And I said, "No." And at that moment, the phone rings, and my secretary comes in, Marcia Bishop, and she said, "The White House, the president wants to talk to you." And good. And so I pick up the phone, and I didn't know what he was going to say, because the year before he'd phoned to tell me I hadn't been selected. But judging the tone of his voice, it did sound good. So I go downstairs on my way home, and all the press is there. I'm not used to talking to the press. And so I just said, well, I can't really say anything until I am, because I'm going to be confirmed, I hope, and there'll be hearings, and we'll prepare. So then I go home, and we're in this little street we live in, filled with press cars, so I can't get into my house. And then... unbelievable. And my children were on a train somewhere, so they came back, and Joanna did come back, and the President Clinton said, "Come down on Friday to the White House," and so we get on in the car and drive out to Logan Airport, and all the press were following, and they grab all the parking places. So I have no place to park. All right, so finally I get on the airplane. And they want to interview me still, though they know there's nothing. So they're all flying first class. Well, I wasn't flying first class. I paid for it. I'm not going to go fly first class. So they're all up in first class. Then they try to come back to interview me, and the flight attendants wouldn't let them. Ha, ha, ha. All right. So then we get to Washington, and I get off the plane. There's supposed to be somebody from the White House meeting us in a car. So we couldn't find anybody. So the ABC man says, "I'll drive you." No, forget that. So we get in a taxi, and I say, "Let's drive around the airport for a minute to the terminals, just see if there's somebody here from the White House." So there was an official-looking car, and the taxi driver leans out the window and says to the person in this official-looking car, "White House? White House?" And so he says, "Take the 14th Street Bridge." All right. Eventually we got there. All right, end of comical story, which is also true. So both the things I've told you are true.
First exercise in interpretation. What did they mean by the White House? So, Justice Shah, you similarly had served on a court before being elevated to the Supreme Court of Pakistan. You were the Chief Judge of the High Court of Lahore since 2009, and you've been serving on the Supreme Court since 2018. Can you tell us about your path and joining?
It wasn't as comical as that, but you see, how I got into this was that, we come from a country where the constitution and the democracy isn't the same as you have it here. We've had tough times where our constitution has been abrogated, which is a thing, I don't know if you're familiar with. These constitutions have been suspended in the country, have been abrogated. So for anybody trained in the rule of law, trained in the concept of democracy, supremacy of the constitution, would, just imagine how would you feel if your constitution itself gets abrogated by some establishment, and they want you to just work under a new order, which is not as democratic as you've sworn to. So this happened, and when the fourth time this so happened and an emergency was imposed in the country, there was a whole lawyers' movement. I don't know if you know about it. In the year 2007, there was a whole set of lawyers' movement because they deposed the Supreme Court judges. The military establishment of the time had deposed the judges of the Supreme Court in the year 2007. So there was a whole lawyers' movement for 2 years, and as a lawyer, we didn't go to work, we didn't go to court, we didn't want to appear before those judges who were appointed under the new regime. So it's a bit of an activist kind of a thing at that time. And when those 2 years ended and somehow the lawyers' movement succeeded, with the help of maybe perhaps the other political forces, the judges were restored and the Supreme Court is back in its original form. So that Supreme Court then invited some of the lawyers, including myself, to come onto the bench, and they said that if you fought for this, if you really want to fight for democracy, said the Chief Justice to me, the best way to do it to be a judge on the court rather than be on the streets and all that. So even though I had no intention of becoming a judge, I accepted, and that was 2009 when I got into the High Court and worked there, and then to the Supreme Court. Yeah. So I think it's been an extremely wonderful journey. And to lawyers here, I would say that, I mean, at some stage of your life, do consider judgeship. I think the amount of contribution you can make is absolutely phenomenal, which a lawyer can never even fathom doing.
So we've heard stories of serendipity and possible coercion as parts of the path to the Supreme Court, but I think underlying that is a lot of tremendous hard work. Justice Shah, perhaps I can ask you, starting with you again, is what does it look like to actually work on the court? What is your caseload like? How do you manage the caseload and the document?
Well, I come from a country the size of which would be, twice as big as California, and has 220 million people. We have about 1.8 million cases in the country which need to be decided. We don't have a very strong ADR system in place, so there are no alternatives. We don't have arbitration, we don't have mediation, so everything goes through the courts. So 1.8 million cases in the country. We have 4 tiers. We have the trial court, the district court, the high court, and the Supreme Court. And we have 17 judges at the Supreme Court, and we run by a constitution. The constitution is very interesting. It sort of runs around, or is sort of based on fundamental rights. We can strike down legislation. We can strike down executive acts. We can force the government to do a positive act. So that's the kind of background we have. So overall, on the court, it's been terribly exciting because we've really, I think, advanced the cause of fundamental rights, keeping away the political cases. I think the court has produced some wonderful jurisprudence, of which we'll talk about later. But it's been very satisfying work as a judge. Resolving disputes, solving problems for people has been personally a very satisfying act for me. It's not about money, and it's not about all that. It just takes you away from all that. But it's a very satisfying, a very gratifying sort of an experience. And I given another life, would love to be a judge again. Yeah.
Justice Breyer, how about you? How would you say that you managed cases when we know that there are often more cases than one could possibly hear, even though it's not to the level of 1.8 million cases?
Could I just, before Mr. Breyer comes in, just want to say the Supreme Court in Pakistan, if you were to compare it to your Supreme Court, we have about 50,000 cases and 17 judges. Now, 50,000 cases is a lot of figure. We decide 30 cases a day. That's a lot of work. I think that's something Justice Breyer would not have heard of before. So we're a pretty hard-working set of judges back home. So
So gauntlet thrown. How hard do you work?
No, my impression, my inner feelings are very, very much like Justice Shah. And I get this question in many different forms. I think President Clinton, I think, said this at one point. I hope you like the job, because the cheering dies away. And it does. I learned what that was like after about 2 years, when a young lawyer at some kind of drinks party at the court comes up and says, "Oh, Justice Breyer, I just think you write such good opinions. Would you please sign my programs?" I say, "Sure," I sign it. As he walks away, he turns to his friend and he says, "Well, that makes 4. You see? Yeah, that's right. And the satisfaction of the job, it's certainly not going to be the paycheck. And it's certainly not going to be the applause, if it exists. If a newspaper says what a brave dissent I write, I really in my heart know that the brave thing to do for them would have been to do the opposite. You see? I mean, forget that. What is the satisfaction of the job? Exactly what Judge Shah said. and that's true for any judge. You have a problem in front of you that matters to people. It's like being a doctor. If you've ever read Camus' book, The Plague, read it. At the end, he says a doctor is a person who just does help other people without a philosophy. He just does it. And if you're a judge, you're sitting there and you know that this case matters to somebody, and therefore you have to give your best. And you have to keep giving it. And maybe it isn't good enough, I don't know. But you can't do better than trying your best. And you keep trying, and you keep trying, and you keep trying. And that's true of every case. No matter if you're in a trial court where it's two people, whatever, or you're in the Supreme Court. And you keep doing it and you keep doing it. And as you get older, it takes a while. It's going to take you a while. But you realize what a privilege that is. What a privilege to have a job where you must behave in that way.
And if I could just add, you see, Professor Rao, you see, the challenges for a judge coming from South Asia are slightly different, and I want you to appreciate that. When you look for a judge, normally you look for competence, creativity, hardworking, and all that. But I think we need to look for another factor when you're looking for a judge in South Asia. You're looking for a person who has courage and who's bold enough to decide, because the kind of pressures and things that a judge in South Asia deals with might not be the same here. So, I mean, that courage and that audacity and that strength that's required in a judge, I mean, normally, I don't know, it's very difficult to find. I mean, we're not really trained in the art of bravery or courage. Normally, a practicing lawyer becomes a judge in Pakistan. So we normally look at his competence and his work that he's done and his, if he's creative, smart, and all that. But sooner or later, we realize that we also require yet another element, whether it all is brave and whether it all is courageous because of the things that happen. So, because it's not easy speaking truth to power. And so I just wanted to add that dimension that there's a bit more expected of a judge back home.
So I want to ask a question about when cases get hard or you find yourself in dissent. Dobbs versus Jackson Women's Health comes to mind. Might you speak about the process of judging and in difficult cases, particularly where you find yourself in dissent, and how you manage those cases or questions or colleagues? Or all
no,
of the
it's
above?
not more difficult. Sometimes the dissents are easier. I mean, it depends on the case. I think the most difficult case I had, which I'm most pleased about, I don't think it's going to appear, but it was Google versus Oracle. And it was a case involving computer language, Java. And I started out knowing about Java, zero. Okay. It took me a copyright case, it was, and it took me a year and a half with 2 law clerks working on this thing to figure it out. And when it came out finally, it was unanimous. It wasn't a dissent. And I felt all of us had learned something. And I read what the commentators who know, these commentators did anyway. And they said we got it basically right, understood it. And so I thought, good, I've done one thing. and you see, that's a hard case. That was a very hard case. And there are others like that. The fact that there's a dissent doesn't mean it's hard for you to decide. It means others don't agree with you. And so if there is likely to be a dissent, what we'll do is shall I spend a minute explaining how the court sort of...
Please do.
All right. First, think this. Unlike Pakistan, I imagine, we have 50 states. And each of those states have a governor and a legislature and a set of judges and laws. And people ask in the 5th grade when I talk to them, which I like to talk to the 5th grade, and I say, look, 90% of the law in the United States is state law. It's not federal law. And you don't know that because the people in Washington like to get their names in the newspapers, and they say it's the most important. Now, I'm not criticizing them. I'm not saying that their law is unimportant. Of course, it's very important, but not all. And you want to help your neighbors and your friends, you go back to that city and work with the city council and work with the governors and so forth. That's where the law is, but we only decide federal law. Congress, federal administrative agencies, and the Constitution. Okay? So we're already in a limited category there. And now, how many cases are there? Well, in fact, you could bring a case with a federal issue in a federal court. And you can bring a case with a state issue in a state court. But you can also bring the state issue in some of the federal courts, most of them, and you also can bring the federal issue in the state courts, and they put all that in there so the procedure teachers have something to teach you. But that's the situation. And so it's a little complicated, but eventually, through appeals and so forth, there are appeals on what? On law. The juries decide the facts, the judge decides the law. That's the basic Hornbook thing. And it's basically true. And when the case is over, the lawyer who loses thinks the judge is a real moron and made a big mistake of law. Does he say that? No, he says that. But he appeals. And what does the lawyer who won think of the judge? Well, your answer's right. What is your answer? Yeah, he doesn't think about the judge. He thinks he's a good lawyer. But in any case, these appeals go on, and eventually we get to a higher court, and eventually you get to the highest court below the Supreme Court that can decide the federal issue, and there are probably 100,000 of those a year, roughly. And of those, probably, 7,000 ask us to hear it. And we'll hear about 70. So it's a tiny, and it isn't, the law is not really made in the Supreme Court, the Court of Appeals, the other are. You understand. Okay, but what do we do with these 7,000 cases? Well, we each have law clerks. 4. And 4 times 9 is 36, and 7,000 divided by 50, and then divided by 36, etc. That's about 150 that come in each week, and divided by 36, that's about 4 or 5, and they write memos. So every week I get a set of memos like that. And you say, well, I should be doing all that work. They shouldn't. And so I say I'd rather have a person called a law clerk who was a bright law student, is a bright law student, done well and so forth, really nice. I love them. And I'd rather have him do it than me pretend to, because I would be pretending to. So I get this, and I figure out which one should we take, and it's usually like this, because the primary criteria is lower court judges have split on this question. They've come to different conclusions. We better take it. They've come to the same conclusion. Why take it? You get the idea? And so every week we're in conference. 4 votes as we take it. Less than 4? Never made it into conference? Anyone can put one in conference. Okay, there we are. Now you get the system. Then once it's granted, then they all write these briefs. I don't know why they're called briefs. They aren't. But there we are. And we have a blue one and a red one and a yellow one and a gray one. And gray is the government, always, and the yellow is reply. You get the point. And bright green for light green for those on the blue side, and dark green for those on the red side. And you can have, usually in a typical case, 15, 20.
But you still get Dobbs in the end.
The what?
You still get Dobbs in the end. I mean, in the sense...
It could be 100.
What I'm saying is that with all that research available to... I mean, we don't have law clerks in that structure that you do. And you get time to write also. There's a lot for an opinion. But things go wrong in the end also at times. You see, things can go wrong. Yeah, so that's what I'm saying, you see.
Yeah, but the normal system is I read the briefs. My law clerks write memos. I read the memos. We discuss them. We have an oral argument, half an hour each side for each case. Yeah, we then are in the conference. We discuss it. And then it's assigned in order, sort of, there's a kind of order. And I write a draft and send it around to my colleagues. And I want to just say from them it says, I agree. That's all. They don't have to say it's brilliant. Just say, I agree. And about 40% unanimous. 5-4s used to be about 15, 20%, somewhere in there. Not always the same 5 or 4. And when everybody's written or agreed, end of case, it comes out. All right, 5 minutes, now you understand how the court works. And what I've just told you is important to keep in mind because the system, the mechanical system, plays a big role in how things end up being decided. And I bet the Pakistan system is not so different, is it?
Oh, we don't have that much time and that luxury of clocks and those opinions and those memos, but we still get it right at the end.
Well, actually, what do you mean by...
No, I don't mean anything by
Can't
that.
be right at the end.
I don't want to get into that. No. Dobbs is not my business. Abortion is not an issue in Pakistan. Our Islamic law answers the question very well, and we have not a single case in the Supreme Court or the High Court on abortion. Islamic law clearly specifies that you have the liberty to go ahead and you have the choice to abort in a certain number of days initially, and then later on with a solid ground, if there is, which sort of is dangerous for the mother's health, or there's a fetal abnormality, the fear for that. So that's it. So I think we don't have an issue on, I mean, we could talk about something else,
Right.
but not abortion.
So multiple schools of Islamic law, and they each have somewhat of a different opinion, but it's still...
Yeah, court would go along with the liberal view depending on the panel of judges. But you see, as I said, the tool, the medium that we use would be the fundamental rights of the Constitution, like right to dignity, right to liberty, right to life. And that's what we play with. And if we have to rely on any material, I would go along with what supports the constitutional values rather than anything else. Rather than regressive view, I would take a positive, progressive, dynamic view. And that's how we've been interpreting our Constitution. So our tools are the fundamental constitutional principles, mainly.
So I think questions of law at the Supreme Court can be hard for different reasons, different definitions for what makes a difficult case. Can you speak to some case that you may have found difficult or challenging, or that demanded courage? I know that the Pakistani Supreme Court doesn't have a case or controversy requirement in the way that the US Supreme Court does, requiring there actually be a case or controversy before a case can make it up through the system that Justice Breyer described and even have a chance of making it on the court's docket. How have you thought of this suo motu jurisdiction? Can you tell us what that is and when you've exercised it and when it took real courage to exercise, perhaps in a hard case?
Well, there are two separate things. There's a hard case issue that I'll talk about in a minute, but let me just tell you about suo motu. Suo motu is this on your own motion, as it means. That's a unique jurisdiction that Pakistan Supreme Court enjoys. You don't have to have a list or a case or a petition before you. And if you think there are fundamental rights of public importance being affected, the court on its own can take up a matter. So if a community is in trouble maybe, or some particular human rights violations taking place which are of a large public interest nature or public importance, the Supreme Court can take up that matter. For example, we've taken up a matter where some workers or laborers in a brick kilns, you see, working in Pakistan, were put under very severe, harsh working conditions. So we took up that matter in a Darshan Masih case, which is a very popular case from Pakistan. We came up and we sort of got them out of those prisons that they were put under after working during the day. So we got them out. We sort of got rid of some, bad customs and traditions like swara, where you want to, if a family dispute is being settled, you have to give a woman to the other side in order to settle a dispute. So if there's a male, somebody's killed a male in your family, in order to settle that dispute, you would give a woman of your family to the other side, and that's called swara. And that would settle the matter, which is, of course, not acceptable by any reasonable mind. Or so this court took that up, suo moto, and said this tradition, this practice is wrong, and this was going on, and so that we've interfered. So things like this. So largely, suo moto is used for such like issues where there's a public importance issue. However, considering that the power is with the Chief Justice to invoke this, it has gone through a very tough patch recently also, and we have, I think, abused it, and over the years now we think the current Supreme Court thinks that this has to be more collegial. We need to sit down and think about what matters, because it's such a strong power, what matters are we going to take up as suo moto and what not. We just can't let it be the prerogative of the Chief Justice alone to get into suo moto and take up matters, because in the recent history, which I don't want to go into, things have not been very encouraging, and which has brought a lot of bad name to the Supreme Court. Talking about hard cases, personally, one of the hardest cases that I've dealt with was a case relating to the tenure of the army chief of Pakistan. So this case comes up, and I authored the judgment. There could be criticism, and I'm open to that also if anybody wants to talk about it. So this case comes up in public interest, and somebody said, what's the tenure of an army chief? Now, please imagine that one of the strongest persons in the country is the army chief in Pakistan. So what would be his tenure? I mean, is he to retire after 3 years, 5 years, or what? So this case comes up, and so we start looking at it. For the first time, I think this thing happened, is a panel of 3 judges, and we looked at the law, and we saw that in the past, whenever the army chief came, they had a different term. I mean, there was no pattern to it. The law provided nothing. It was surprising. The law had no terms and conditions for an army chief, which we thought was very interesting. And so there was no law, and the practice was, incongruent. I mean, there was time when there was an army chief for 9 years, for 11 years, for 5 years, so we could not draw on any practice either. So we didn't know really how to deal with the situation. And the best thing we thought at that time was that let's send it to the parliament to set the law. I mean, why should we 3 judges decide what should be the term of an army chief in the country, which is a very important position. I mean, he is in charge of the army in the country, which is a very strong force in the country for reasons of our, the way the country is structured. So we said, no, we're not going to touch it, and we're going to send it to the parliament. We give parliament 6 months to decide what should be the tenure of an army chief. And this particular chief whose case has come before us, we don't know. I mean, he's spent 3 years already, but let them make a law and let the parliament and the people of the country decide what should be. So we exercised judicial restraint and sent the matter to the parliament. We, however, said that if the parliament does not decide within 6 months, then drawing upon the practice in the past, we would say that 3 years is the term, and the term will finish after 3 years, and this particular army chief is going to go home, and they're going to get a new chief. But the parliament did come up with a law, and now we have a law in the country which decides what's the age of retirement and what terms can he get, and can he get an extension or not. So we thought that was a bit of a very unusual case that had come to court, where we were dealing with the army, because we were looking at laws that had not come to court before. We had not looked at the Army Act before with that kind of seriousness. We were surprised to see that there were no terms and conditions and stuff like that. So there were other things also, but this I felt was a hard case to handle. But we thought the best way out was to give it to the parliament, rather 3 judges deciding what's the fate of an army chief in the country.
So that would be really unusual to even imagine something like that in the American context, where you might decide something narrowly and then hope that if Congress and the people disagree, they might correct or override a narrow decision, but nothing like a default ruling that's also narrow and specific that would force Congress to decide. And I wonder, even if that were the case, it would motivate Congress to act in a timely way. We don't have anything like the suo moto jurisdiction, but we have something that's been called the emergency docket, where the Supreme Court decides cases that haven't been fully briefed before it in its regular merits docket. And it's been subject to a lot of criticism, that the cases, for example, the COVID cases, the most recent death penalty cases, really should have been briefed before the court and decided in a full merits set of cases. What would you say about the operation or practice of the emergency docket in the last few years to those criticisms?
I think that when you say an emergency docket, look, you have a case in a federal court or a state court, you think it might come to the Supreme Court, and there's been a decision, or there might be, and you think that decision is going to hurt you before you have a chance to get it to the Supreme Court to get it reversed. And so you ask for a stay or an injunction if it went the other way, and temporarily. And the normal, for years, these arose, there are two instances where it would arise. Each one of us is responsible for a certain area of the country. Like for the most of the time, my first few years, I was responsible for the 10th Circuit in these matters, and later the First Circuit, which is around here. And so you would ask the judge responsible for that stay or for that injunction, temporary injunction. They almost all were death cases. That's person in a death case has probably had a lawyer eventually who knows what he's doing, and they may have been to the court many times in many years. But if the execution's about to come up in 2 or 3 weeks, they'll come up again, and they'll ask for an injunction, and while we hear their case. My experience is that most of them, or almost all of them, they're not going to get their case heard. They've been had it already. I mean, there's no good reason for taking the case under the law, etc. But sometimes there's a point. And then we might grant an injunction while we then consider whether to take the case and then take the case possibly, okay? So that would happen a lot. That's what these were about. The second category is I get out of the First Circuit, somebody says, please enjoin this, and I had a fence and my cat went under the fence. I mean, something is obviously nothing, all right. So forget that, that's denied. Now, if the person wants, he can go to the whole court when the one judge denies it. That happened once. You know what happened was Justice Douglas was out in California or somewhere. It was about April or something, and Halpern went to him and asked him for an injunction against the Vietnam War. So Douglas puts on a tree, come to the courthouse and argue this afternoon. And they went to the courthouse and they argued it, and Douglas issued the injunction. So it took, I think, a very short period of time, like a minute, before the rest of the court reversed that. All right. Anyway, but there we are. You get how it works. All right. What's happened in the last 2 or 3 years is a new subject would come up, namely COVID. And COVID gave rise to a lot of cases. Where people were saying, I don't want to be vaccinated. There's a law saying I have to be vaccinated, but I don't want to. It's against my religion, for example. That's different. All right. And by the way, if you wait to take this case, I am going against the tenets of my religion. So that came up in several different guises, in various ways. I was on the side typically which would say, I'm sorry, but this is a serious disease and you better get vaccinated so other people don't get it, however you feel. But that was not the view of every member of the court. In fact, in some cases, there was a majority the other way. And so they would sometimes grant a stay or grant an injunction because of what they felt was the religious importance. It should be stayed or the injunction granted until the court had the time to decide whether to take it, and then if they did take it, it would be heard in the normal course. Now, it is not always one way or the other, but it is not necessarily true that they're not fully briefed. I mean, you could come up. That depends on the lawyers, and it depends on what the issue is, and it depends on how many amici they have. But I mean, quite often it is very fully briefed. And sometimes when it is, when the court, when members of the court are thinking, maybe we should grant this injunction, or maybe we should grant this stay, they can do this, which they did on at least one important occasion. They say, we will refer this to the whole court. We will not stay it until we've heard the full argument. And maybe 2 weeks later, there'll be a full oral argument, and people can add the briefs. There's nothing to add. They've had everything there. And they did that at least once. So it was fully decided in the sense they got all the briefs and arguments, but it didn't follow the normal course because they wanted it right away. Okay, so that a lot of different things like that can happen. And because of the nature of the issue, the procedure got involved in a lot of the public criticisms. Were they right? The public criticisms, I thought some were overstated. Some may have had a point in the particular case that there wasn't enough. On the merits, which I thought were more important, by and large, I was against allowing the individual to say, I don't want to be vaccinated. There was a Navy SEALs case in one, and some other ones, but you know, the country was a lot divided on that. But that's the issue on the merits. And whether you should take it on the emergency docket and how you should postpone it and what you should insist on, that very much depends on the case. And the court has a lot of discretion there.
So one benefit of having justices from 2 Supreme Courts is to ask about how another jurisdiction might handle a case like this. Yeah. I mean, it's not unique, obviously, to the United States, given that we were in a global pandemic. How did the Supreme Court in Pakistan handle?
We had 2 major interventions, actually. One was that we largely went for judicial restraint. And the interesting part and the tricky part was that some of the religious groups had come up and petitioned to the court that they have to have Friday prayers in a congregation. There were Eid holidays, a festival, Islamic festivals that we have around the year. So they said, how could there be an Eid without a namaz or the prayers? So we need to congregate. And they came to the court to permit them that they must congregate. And the court exercised judicial restraint. They said, let the executive decide that question. That's based on science and medicine. We have nothing to do with it. And it's designed on public health, and larger public interest requires that we don't interfere. So I think that was a very wise decision. Several high courts did not interfere. The other interesting part was that one of the high courts did something fantastic. They granted an en masse bail to a lot of prisoners because our prisons are obviously, like many other countries, overcrowded and had no basic health facilities. So Islamabad High Court went ahead and granted bail to a number of offenses, not including death and life, but other offenses. And they said en masse bail was granted to a number of people, and a lot of prisoners came out, of course, under bond. And so that was a very progressive decision. However, later on, the Supreme Court modified it somewhat, which I don't agree. But I would flag the Islamabad High Court judgment, saying that was very good on their part. So these were the 2 main interventions as far as COVID is concerned. There was one other intervention by the Supreme Court, which I thought was a bit of a, that's my personal view on it, is a bit of an overreach, where we start regulating the markets. Whether at all a mall should open at a particular time and shut down at a particular time, because a lot of business people had come to court, and the shopkeepers and all had come to court saying that we should be allowed to open shops till late and all that. And I think it wasn't our business to regulate their timing, but the Supreme Court did open some malls and markets and saying that they can go ahead and open it for certain hours, which was hailed, of course, by the business community. Thought that was very good because that was affecting their business. Personally, I think that wasn't our domain, but so these are the 3 kind of different interventions that we had judicially in this matter.
So a question on the first intervention, as it might relate to Islamic law. I I know a lot of folks are aware that the Pakistani constitution is considered one of the some 24 constitutions that designate Islamic law as a source or the source of law. And it is plausible, and in fact, it did happen that many muftis, people issuing opinions about Islamic law, fatwas, said, well, out of necessity, you don't need to attend Friday prayers, or you don't need to attend the Eid celebratory group events after Ramadan or the Hajj. Would that have come into plausibly the Supreme Court's analysis at all, or on questions like this, is it always a matter of judicial restraint and keeping it
Well,
local
certainly
to-
it would have. I mean, somehow none of these cases came up to the Supreme Court, and I think they didn't petition before the Supreme Court. I think you see how we look at it as I think Islam and the entire religion, entire Sharia is based on reason and logic, and we thought it would be wrong to put everybody's life in danger. And I don't know if any religion, in particular Islam, would say, go ahead, go pray, and everybody gets affected by COVID. So that was pretty simple for us. We exercised judicial restraint, but we thought initially that there would be a reaction from some of the Islamic groups, but there wasn't any. And then some of the fatwas, as you just pointed out, and some of the other decrees came from some of the religious sects saying that, we should also exercise judicial restraint. So it went smoothly. But I think the judicial approach was rather correct, to err on the side or in favor of science and the public health rather than basing it on any other emotional religious belief or something to that effect.
Great. So I have a question for you, Justice Breyer, about prisons, but I also think I should pause here to encourage anyone with your own questions to please write them down on the cards here and pass them forward. We can start to collect them in the next couple of minutes as we wrap up in the next 15 minutes. My question for you, Justice Breyer, has to do with questions of exigency, like the idea of overcrowded prisons. We are living right now in a time of mass incarceration, over-criminalization, crowding in the prisons. There was, of course, so I teach criminal law, and I know a lot of my students have been wondering about this. With a case like Brown v. Plata, that the California case where the Supreme Court affirmed this decision, state law decision to issue, I'm sorry?
When they closed, when they had
Ninth Circuit decision to release a certain amount of offenders with a lot of parameters around the nature of the offense. So this wasn't COVID related, but it could have come up in a situation like this. So I wonder, would you have any advice for a lawyer seeking to tackle structural questions like this one through the courts, as happened in Brown v. Plata, whether it were in a situation of emergencies like the one that arose in Pakistan with, issuing a mandate to release certain amounts of prisoners, or any other case where there are issues of fundamental rights involved, particularly in the criminal justice system?
Well, I want to make a general point. When you listen to Justice Shaw, I think an awful lot of the things he thinks are correct. And the way he's been putting it, in Pakistan, it's somewhat easier to get to what I think of as the heart of the issue, which usually has to do with a constitutional value or a common sense value. And I've been emphasizing all these rules here, but don't be hypnotized by the rules. He's not. And if you're there long enough, I'm not, maybe. But there is a very basic thing going on in law as the extent to which you try to push issues into a format where you get rules, as opposed to giving the judge more freedom to look to the basic values. And read about that, find out about that. That's important if you're going to be lawyers, and you have to work it out in your own mind. All right, now, a separate question. I was on the Sentencing Commission in 1986. I was involved when I worked for Senator Kennedy, helped write the statute. The Sentencing Commission, at the time, I thought, sentences are too long, and particularly mandatory minimums, which I've spoken about. I've spoken about publicly a lot. So is Tony Kennedy. Mm-hmm. And but what well, maybe I'll make a correction here, and this is just an impression. It isn't now that the prisons are overcrowded. They may be, but you start reading, if you haven't, a few of the opinions that were written, say in Puerto Rico. My God, I mean, it was the judge there just released the people and said, you better reform that prison. This is in the 70s and in the 80s. If you look at Joe Toro's opinion about the mental health facility out here for retarded people here in Massachusetts, it was happening all over the place. This is not something new that's just suddenly come up. It was happening all over the place. Now, that isn't to say it isn't happening, and it isn't to say there's nothing to do. But this is, first, maybe there are places where the prisons have reached the point of overcrowding that you've got the same kind of circumstance you had in the California case, or that you had in some of these earlier cases, and then you can go to the judge and say, go judge, do something, look, here's the law. That doesn't hurt. If you can find them, and it's really so, and so forth and so on. But the second thing will come as a slight surprise, maybe, but where I think the most room to achieve something is to convince people in Congress or their constituents about how expensive this is to keep people in prison for such a long time. Because when we're sitting there around the table with the Sentencing Commission, there's a certain amount of compromise going on, and we were looking back to what judges normally did. And we thought, if you're going to keep somebody in, people who do commit crimes, unfortunately, are younger people. And older people don't, rarely. And so, but they are very expensive, older people, to keep in prison with medical care and all kinds of stuff. So they'll figure it out. They'll figure it out. And we're getting there. And so doing things that you can think of to do to emphasize the cost of this, I think it helps. And the third thing, which we could never get going, but we certainly tried, is what we used to call alternative punishments. Now, alternative punishments are a whole bunch of things for people who have committed crimes, but they're not too serious, and they're younger. Where did I find the best one working? You'll never believe this. In Spokane, Washington, on an Indian reservation. My God, it was fabulous. And there was a woman who was the judge, and she had this thing going so that some of the younger members of that tribe who would get involved in drugs would come to her. She'd be the judge, and she'd say, now here's what you're going to do. I want no uses drug-free in your life and you're there once a week, and I have 2 people who are going to look to see what you're doing, and boy, you do this again, you're in trouble. You say, but he was not in prison. and there are bunches of things like that. And read about those, as you have. But read about them, and then you find targets of opportunity, and you go to the places and say, hey, the Native Americans, oddly enough, in Spokane, Washington, and you want a good family law program, try the Navajo tribe. Fabulous. and we're not doing this. There's no condescension in this whatsoever, I promise you. And you just say, hey, why don't we try this? Why don't we try it? And there are a bunch of sentencing commissions across the United States, in different states. So I've always thought the best chance is convince them of cost. The best chance is find 15 different forms of alternative punishment, and you go bit by bit by bit by bit, with group by group by group, and then maybe you get somewhere. And you still can go to court if you get a bad situation.
So there's a reason that Justice Breyer is known for being the pragmatic justice. We have some questions coming in, and as I take a look at them, I want to ask you, Justice Shah, about something we haven't raised yet, but that is obviously of concern given the huge flooding crisis in Pakistan. How does this touch on what the court does, and what has the court done in this regard and on climate change?
Thank you. Well, the floods have been devastating, and I'll come to the floods just a while. Let me just start off with floods, saying that Pakistan, 33 million people stand displaced, and as the UN Secretary General Antonio Guterres said that the monsoons were on steroids in Pakistan this year, and that's because there was the hottest temperature this summer. April, May was the hottest, and of course, hot air carries more water, and the glacial melt due to temperature rise. I mean, things were devastating. So 1/3 of the country is underwater, and we're talking about food security issues, health security issues coming up. But what I want to raise the question here is, and which is very important to my mind, that we've been looking at, Pakistan has started looking at climate justice as, and there is very strong jurisprudence coming out of Pakistan on climate justice. We started off, we have a rich history of environmental justice. So that environmental justice kind of relates to, local pollution, national jurisdiction and all that. And enter climate, which is, the polluter isn't there. I mean, Pakistan is a country which is not contributing towards emissions. So mitigation is not Pakistan's problem. Pakistan's problem is adaptation. Pakistan suffers at the hands of climate change. So the entire jurisprudence coming out of Pakistan is adaptive jurisprudence. We look at a whole lot of things to deal with climate, you see. We look at agriculture, forest, irrigation, disaster management, and that's what the court looks at when you're looking at climate justice. So, and we've come up with interesting, and you can have a look at those, where we've directed the government to start implementing the climate change policy. The court has also created a climate change commission for the government to sit down with experts and people like WWF and IUCNs of the world to sit down and carve out solutions on how to deal with this, and realizing the urgency, and more importantly, realizing that how deeply it affects fundamental rights of ordinary people and largely their dignity, because they're totally uprooted. So while we were grappling with these issues, and some of the jurisprudence has already come out on urban planning, on shutting down a cement plant, that they can't expand because it's a water-scarce country. You can't have a cement plant because cement plant is a water guzzler. You can't do this, especially in the context of climate. And we coin terms like water justice, intergenerational justice. We've also come up with a term called climate democracy that we need to follow. That's the kind of country we need to have now in future. And I think climate for law students is absolutely important area for the future. So, but more importantly, the flood hits us then. And now the issue is loss and damage. Who pays for all this? I mean, we haven't done this. And we're talking about $30 billion, one estimate, the early estimate that has come out. And US is pledged by $50 million maybe, and the rest of the world we put together maybe $150 million. What is that compared to $30 billion that we require? So where do we go? So that's where the enforcement of this now comes up. Where do we go? And I think for the first time we start talking about a climate global court. I mean, where do we take our matter? I can't do anything in Supreme Court sitting in Pakistan, getting money out of the countries who've probably caused all this. So where do I go? So now they've started thinking about having a global court that enforces this maybe. And one thought so far that's still doing the rounds back home is that some of the Pacific Island countries, and Pakistan might be a part of it also, that's an executive decision, so I don't know, to take up the matter before the ICJ for an advisory opinion on the issue. Now, advisory opinion is not binding, but it has a persuasive value, and that could be just a start towards a global court. So to me, right now in Pakistan, countries in South Asia, the most important issue is loss and damage. Where do I get this money, and how do I enforce it? So it could be, I can't do it as a court, but I could certainly raise it here in this forum. That I find to be the most important judicial or adjudicatory issue that we need to solve, because right now the country is under serious trouble. I mean, we're talking about a number of people, 1 million houses razed to the ground. As I said, 33 million are totally out. They're just totally displaced. So there has to be some answer to this. And with 30 billion being the bill so far, which I think is going to go up, $30 billion, where is this money going to come from? Considering that if you look at the emissions internationally, the higher income countries have contributed about 60% to these emissions. And their population in the world is only 15%, and the rest is us. So, I mean, to me, the cutting edge question relating to courts, law, enforcement would be, how do countries like Pakistan, and this is going to happen again, and it's not one time, it's going to happen again and again, because how are you going to deal with glacial melts, and how will you deal with temperature, and how will you deal with monsoons, which will keep coming? So we need to build dams, or we need to do whatever. I'm not an expert in this, but I need to know, how do I enforce this, right? So that's an issue that's important.
So unfortunately, our hour is coming to a close. I will get to at least one question, or two questions actually, but in a perhaps unfair way. I'll ask these two questions, but then ask each of the justices to give it a 1.5 minute response, however they choose.
Can I just ask a question from Justice Breyer?
See, we're going to have a third question.
Can I?
Sure.
You see, this has been perplexing me all my life, and I thought...
A deep question at that.
And I thought I'll never get Justice Breyer on the table again, and I won't be at Harvard again. So I thought this was just fits in here. And the question is, you see, I take, this is a question about the scope of academy and academia. So I take it that schools like Harvard, schools like Yale and others, wonderful schools in the US and wonderful academy. And if I were to go through 4 years of JD or whatever program here, my DNA would be built with rule of law, supremacy of the Constitution, democracy, and I would be, every part of my body would be, filled with all that, the ethos of democracy and all that. So what I don't understand is that when people come out of this school, these schools and these higher schools, this academy, and go run the state, they go messing around with democracies in the world. Where does it go wrong? I mean, what am I missing? What am I missing? No. I mean, you don't need to answer that.
Well, it touches on one of the questions from all of you, so I'll ask this as an addendum, and that is, what do you see as the link between legal education and the judiciary, or put differently, what piece of advice would you have for a student who wants to be best equipped to go argue before a court, or perhaps to join a court? So I'll leave it there for you.
My father's advice to me was good. His first advice, remember he grew up in the 30s. First advice, stay on the payroll. I managed to do that. His second advice, which is more relevant, he says, do your job. Do your job as best you can. And when you're doing it, listen to what other people say too. It isn't such a bad thing when you have an opinion to find somebody who has the opposite opinion and talk to him about it and see what he thinks. All right, you do your advice, you do your job, do it as well as you can, listen to other people, and you might get a better job. On the other hand, you might not. And if you don't, you still have the satisfaction of having done your current job well. He says, you see, it's no lose. That's the best I can do.
And another question from the audience has to do with service on the court. Are there ways in which judges can come together, justices can come together to create some sort of comity or agreement rather than having what looks to be intractable disagreement with split decisions? So is it something that judges can do better, and by extension, those in possible training to be judges should be thinking about, or is agreement something that just happens or it doesn't?
Well, my take on this is that we're not a trade union, you see, we're not an association. The construct is that everybody's independent and everybody takes up an opinion on the matter. However, it will be nice that we tend to get consensus if possible, talk to each other and reason with each other. But at the end of the day, I think one has to stand up to one's own conscience and one's own understanding of the law. And I think that's the construct of a court. It's not as if the Chief Justice agrees and we have to all agree, come running. That would be running a trade union or something to that effect. That's not what it is. So keeping that in mind, that everybody stands up independently, I mean, the culture of dissent is beautiful in a court. I think that's absolutely beautiful. We didn't have this much, has started coming into our court quite a lot. I think the beauty of the court is the dissent. And let me just add that I love Justice Breyer's dissents. I mean, his liberal view on dissents, makes me think that he's just like a Pakistani judge. So I really enjoy his dissents, even recently in the environmental case as well as Dobbs. And I think Pakistani judge would have taken that view, certainly. So on the other hand, yes, while deciding a matter, we would prefer that we talk to each other, and if it's a unanimous decision or majority decision, because it carries more force and, it has to become law of the land. But not to the extent where you compromise your position. That is important. There is a threshold. I mean, you would go to a certain extent. At times, you would let go of certain aspects of our decision making. We say, well, okay, we'll agree on this. We can compromise on this, as long as we have a consensus, but not at the expense of just letting go of the whole thing, you see, and disagreeing with whatever you have in mind. It has happened in our country before. Very able judges have signed away a matter and agreed. I don't know how. But I think we must be very clear that dissent is the beauty of a Supreme Court, and it should be retained, and it has its own character, and that character must be retained. But other than that, efforts should be made to come up with consensus, but not at the expense of your principle or your conviction on the issue.
Well, I
think I would say something on that, because I think it's relevant to you. And you just in the last sentence said, and just what point? Because I think my dissents are failures. Because they're not complete failures, because people will listen to some degree. And I won't get everything I want by any means, but I might get this much. And so I worked for Senator Kennedy for several years. And I know he taught me a lot. And I think it's relevant to you right now. Because one of the major things, and my law clerks gave me a mug which has Kennedy's main things there. First, compromise if you can. Now, the question is when, up to what point?
Up to what point?
But compromise if you can. Look for ways. Better to get 30 or 40% of what you want than 100% of nothing and being a hero to the New York Times. Okay? Yeah. Straightforward. And how? How? Well, what Kennedy would say is listen. Listen to what the other person is saying. Don't go into that conference thinking, or wherever you're going, ha, 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 I have a better argument than you. Because all that produces is the other person thinking, ha, 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 I have a better argument than you. That gets nowhere. You listen to what they say. And what he thought, Kennedy thought, is get them to talk. And if they talk long enough, you will hear something that you actually do agree with. And as soon as that comes out, you say, what an interesting idea you have. What an interesting idea. Let's see if we can't work with that. And if you do work with it, and you do get some success there, and it does work, remember that credit is a weapon. He'd say, don't try to get the credit. If the thing works, there'll be plenty of credit. You don't have to worry about it. And if it doesn't work, who in heaven's name wants the credit? Okay. And so I saw him so many times with Hatch or Thurman or whoever it was. And the press would say, Senator Kennedy, this bill, this looks pretty good what you've done. What I've done, I want you to thank Senator Hatch for that. He thought of this way around our difficulties. And you work with that, and you do it, and you listen, and you both find out where the other person's coming from, and you're able to work out things. Well, I think that's an important ingredient of having a successful country with 331 million people of every possible race, religion, national origin, point of view, you name it. And they have to live together. And that's what I mean by saying listen and work with others. And that's true everywhere, including the Supreme Court of the United States.
So wonderful. I wish we had the evening to continue the discussion, but unfortunately, we will have to wrap up now. One note of dissent that I would make is a dissent to your note about dissents, and that is channeling my friend who used to be on this faculty, Lonnie Guinier, who talked about demisprudence through dissent, that we can sometimes gain ideas about alternative approaches to justice, to sentencing, to some of the fundamental issues that come about through reading dissents like the ones that you authored, Justice Breyer. So allow me to offer a friendly dissent there, but I hope that we can come to consensus, easy consensus, that this has been a generous and generative session for which we thank you, and an honor for, it's been an honor for us to have you. Thank you, Justices.